Welcome to Money Matters. I'm Allison Hinson, and today we're going to talk about the thing that no one wants to talk about. What happens after you die? What kind of paperwork and other pieces of information do you need to put together in order to make sure that your friends and relatives and family have what they need in order to take care of the things that you've left behind, like your money, your kids, your possessions? So we've got an expert in today to talk about that. So Amy McNally, welcome. I know that you're an attorney with Woodman Edmonds in Biddeford, Maine.
Yes.
And thank you for coming in to talk about the topic that no one ever wants to talk about. I know that I have to pay taxes to the government, and I know that I'm going to die. That's all I know about the rest of my life. I hope I'm not going to die for a long time, but it's going to happen. So I know that there's some sort of paperwork that I should be putting together to make things easier.
Sure, absolutely.
And the first question I have is, I'm dead. Why do I need to worry about this?
Well, I think it's really important to consider a few things. Is what do you own and who's your family? What are your goals with that? Are there certain family members you want to support? Are there certain family members you need to provide for, whether that's minor children, a spouse, disabled children, things like that. Everyone has their own circumstances, but thinking about what do I own and who do I need to provide for is really important for after you die.
So let's go to the juicy part. What if there's relatives I don't like or family members I don't like?
Sure.
Can I make sure that they don't get anything?
Absolutely. You can certainly provide precisely what your wishes are in a will.
So a will basically will say, here, as you said, who do I need to take care of? Because depending on when I die, whether I'm younger or older, if I'm older and maybe the kids are out of the house or perhaps I don't have any kids, I don't really need to worry about providing for anybody. But if I'm younger and I might have a spouse or a partner and kids, I've got a bunch of people I need to worry about.
Right, exactly.
So will a will do that for me?
A will do that for you. It will depend, everyone's circumstance is different. So sometimes a will might not provide entirely for it if someone has life insurance policy or owns their home with their spouse in a co-ownership. That will all go to their spouse, or the beneficiary of their life insurance will get the benefit of that money. So everyone's circumstance might be a little different. But if a young married couple wants to provide for when they both pass away, so if they're both dead and there's no one left to get the house, who gets it and how? But then also if there's young children and both of their parents are gone, who's going to be that child's guardian? And appointing someone to be that guardian is something you can do in a will so that the court can say, well, this person obviously designated this person to care for their minor child.
So let's pretend I don't have a will. Let's pretend my husband and I do not have a will, but we have a child. So he dies without a will. Do I automatically get the kid? I mean, our child will automatically stay with me.
Correct.
And in a perfect world, all of his money will come to me.
In a perfect world, yes. Depending on the circumstances, depending on the nature of how everything was owned, yes.
So we own the house together.
Right.
Maybe he's got life insurance and his life insurance states that I get the money.
Right.
So that seems pretty easy. So he's died without a will. I still get the child. I still get his life insurance. So why do I need a will? Because he died and there's no problem. I got everything.
Because if your young child is under the age of 18 or still needs to be cared for, maybe even in college age, there needs to be some designation about who gets something when you pass. And I think that's the hard question too, is what if when I pass, the last parent passes?
So let's say he has died, not a will, but everything went smoothly. What motivation is there for me to do this? Nobody's going to come knocking on my door and say, oh, by the way, today's National Make-A-Will Day.
Right.
How, I mean, I don't want to think about dying.
Right.
Nobody wants to think about dying. I don't want to think about my child without a parent.
Right.
But what's going to get me to go, and I assume I have to call an attorney to do this. What's going to get me to an attorney? How do I even get to an attorney to do this?
Sure, I think those are all great questions, and I think first is having a conversation the same way you prepare your taxes every year or you pay your home insurance to protect against catastrophe. Like preparing a will or preparing for something beyond your life is something we just need to start making part of our to-do list. Maybe a New Year's resolution to get a will, something to plan ahead amongst all the other things we do to plan ahead. It's certainly really important in thinking of your child without a parent or without the resources or a family conflict if you don't direct where the money's going to go. I certainly would recommend seeing an attorney to do that. I think that there are many resources to find a reliable attorney who has experience in estate planning. The Maine Bar Association has a referral service. A lot of family and friends might be able to make you a good referral. And there's always Google or Yellow Pages to see who in your area is experienced in estate planning and you might be comfortable with. And then making it a point or a goal to schedule that appointment, which sometimes can be that hoop or that hurdle to get over, right?
But you used the phrase estate planning. What if I'm thinking, I don't have a ton of money, maybe I don't have any money.
Right.
Do I still need a will? I mean, because estate planning sounds so, it's only for the rich people.
Right.
What if I really don't have anything? Do I need, what if I'm young, I'm 23, I don't have a child, I don't really have anything? What if I'm that person? Do I still need a will?
And the answer would depend on what you own and who you would want to get that in any event, right? So if you don't have a child to support, maybe you have less motivation to get a will, but in that case, your parents, if they're surviving, might get it under the law. If you didn't have a will, is that really what you want to do? Or do you have, is there a significant other or a sibling or a nephew or niece that you would prefer to get some benefit if something tragically, were to happen from you? Something to think about. Maybe not as important of a priority if you don't have the young child or extensive assets, but still something to think about that if you don't have a will, the law, the legislature will dictate where your possessions go and how.
And that's where I think when I'm young, doesn't matter as much.
Right.
But then by the time I get a spouse or a partner, now say I'm not married, but I'm living with somebody, and maybe I never want to marry them, we just want to live together, can I have a will to give them money?
Absolutely. Yes.
Even though we're not married.
Right.
So at that point, let's say we're living together, we have a kid, and something happens where I decide I need to get a will. You say I can look in the Yellow Pages, I can Google it, I can ask friends or neighbors, but I think it's still intimidating to call a law firm because they always, in fact on TV, you walk in and everybody's dressed really nicely and they're wearing suits and it's all quiet and you're afraid, you don't want to come in your jeans, but do I really feel like I have to get dressed up to go in?
I would say no. I mean, I think I say estate planning, most attorneys I know are very casual beyond the suit, and they enjoy that and appreciate that in their clients, particularly if it's especially a very intimate family kind of or personal project that they're working on with their client. I think that's really important. So I wouldn't be intimidated, and I certainly wouldn't expect any kind of judgment to pass from an attorney, particularly in a circumstance where someone's looking to make a will and provide for their family or provide for a situation and make it better in the future.
Now, if I pick up the phone, I finally, gotten, okay, I've got to make this phone call, and I pick up the phone, do I have to have everything thought out? Because I'm calling because I have no idea what to think. Everybody says have a will, but what does that really mean?
Right.
Can I go into an attorney and have them maybe give me a list of questions that I need to go home and think about?
Absolutely. I think that's really common practice, and I think that's probably best practice from an attorney standpoint is to really kind of, you're the one getting this information from the client. I mean, if you don't ask the question, you're not going to get the information. So typically an attorney a lot of times they have intake paperwork or questionnaires that really can guide a client through what information is necessary in a will and what does an attorney want to have on file for preparing a will. So if you do pass and they need to do the estate, then all that information is also in there. But yes, absolutely, the attorney will more often than not guide you through that process, elicit that information from you because it's necessary to make sure these documents are compliant with the law and your wishes.
So I've got the list. So I get to the law firm, I get the list. How do I start this conversation with a family, especially if I have young kids? Like, hey, everybody come to the table. Let's talk about what happens when mom dies. I mean, that is not really the way that I want to do this. So how do I involve other people?
Right.
Do I need to talk to my kid about this? How do I find somebody? Because I think if I die, I mean, my worst fear is that my husband and I would die together, and now we're leaving a child.
Right.
How do I find out who's going to take care of my child? And worse, what happens if I don't say who's going to take care of my child?
Right, exactly. So I think those are really important things to consider. And I think to your first point is it's got to have a conversation you have with yourself. What would I want to happen when I pass? And I think that's a really hard thing to do. And then also having a conversation with, probably in the example you gave, with your spouse, so that you're on the same page as to who you want your child to be with, and then extending that conversation slowly to whom you need to, in order to kind of gauge permission or acquiescence in that regard, to make sure that everyone would be on the same page. It's not an easy conversation to begin, but I think you have to start within yourself and then within your immediate spouse before kind of reaching that goal of this is what we would want. And you have another example of kind of a common disaster when spouses pass at the same time, and then if you don't have a will, the law really governs, and it could be aunts and uncles from different sides of the family that have the same priority to be a guardian, having competing petitions to be a child's guardian in court, and maybe that battling out in court as to what's the best interest of the child and where that child goes. That's one example of what could happen if someone's not named as a priority by the biological parent to be that guardian.
So as a parent, let's say I'm putting together my will, and say I select Auntie June to be the person that my child would go live with.
Sure.
Do I have to tell Auntie June that, hey, if I die, my kid's coming to you? Do I really have to tell her, or can I just write her down in the will and just say, hey, you know what? She can figure this out.
Right. I mean, I think the best practice would be to tell her. I mean, you want her on board. You want to acknowledge this responsibility that could very well come her way, and make sure she's poised to do that in that case. Arguably, no, though. I mean, arguably that appointment would take priority if it went to court. So she would have the priority over anyone else to become a guardian. So yeah, best practice, definitely have a conversation with Auntie June about that, and assess her willingness to be that person. But no, I mean, you don't necessarily have to, get her permission beforehand. Again, I think it would just be best practice.
Now, you talk about priority. What if I don't? What if I die and I don't have a will? Let's say, I'm single, I've got a kid, maybe, the biological dad's out of the picture. What happens? I die, I don't have a will. Who's going to get my kid?
Well, and that's really unclear in a lot of circumstances, unless every family is different. So it would depend the law would kind of give you a priority of which heirs or which relatives have priority, and then they could petition essentially in the probate court.
But what if it's somebody that I definitely don't want my kid to be with?
And unfortunately, no one would know that, because there wouldn't be anything in writing to demonstrate that.
So by basically, a will is a written document that says, I'm dead, here's what I want to have happen. Yep. So I can put whatever I want in this will. Within reason. Within reason.
I mean, so there's definitely caveats for like how long you can take control over property. Like you can't forever manage property beyond your death, right? So there's certain circumstances where there's got to be an end process to the disposition of property. But as far as appointing a guardian, making your priority known is kind of what the purpose of it is in the will and under the statute.
So I can, and when you say appoint a guardian, that's legal speak for who gets my kid.
Who gets my kid? Right.
Yep. So I'm in a will. I can say, here's who I want to get my money. Here's who I want to get my kid. And to me, that's pretty much what a will needs to be.
That's exactly right. Yep.
And that's probably what 99% of what people need. Now, I admit there's probably people who have more complicated things.
Sure.
So for that, can any attorney handle that? I mean, can I just call up and most people will say, oh yeah, we've done that a million times before?
I think attorneys are more cautious about staying in their kind of arenas of where they specialize in and where they have experience, and typically they advertise that appropriately on their websites or through any referral services they're tied to. So you're going to know if this person, because simple wills are still easy to misstep on if you're not familiar enough with the law. So I certainly think that it's best practice to get someone who has done it before and has experience of it and really kind of is one of their arenas that they practice regularly in. Because even the most simple will, the example you just gave, if you misstep on certain things that are required by the statute in the actual document, that could invalidate an entire will, for example, if there's not enough witnesses or if the language for attesting it isn't correct. So whether even if it's a simple will, in theory, it's still good to have someone who has enough practice and experience to do it, I would think.
So if I've used my attorney maybe 5 times for my drunk driving conviction,
Right.
they should not do my will. Maybe I should ask them, who would you recommend?
They would probably refer it out. I think I would anticipate someone in that circumstance who maybe does exclusively criminal law would give you the name of another attorney.
So maybe, hey, I'm turning a new leaf. I'm not going to
Yeah.
do criminal. I'm not going to be a criminal anymore. I'm
Right.
going to go get a
I'm gonna
will.
save my money.
Can you recommend somebody?
I think that's actually a great, if you have an attorney that you have a relationship with who isn't necessarily practicing estate planning regularly, he or she would certainly have a name, I would assume, to give.
So before I die, there's a couple things. Let's say I have an illness and maybe I'm in a car accident, unfortunately. Again, these are the things I'm going to knock on wood. I don't want to have happen to me.
Yeah.
And I cannot, I'm in the hospital. I can't tell people what I want.
Right.
Is there a document that I can have that says my spouse, my partner, my best friend, my aunt, my uncle, my child,
Right.
they get to make these medical decisions for me because I cannot. Maybe I'm too, I'm in a coma, I can't physically do it, I can't mentally do this. Is there a document that says, okay, some other person can make these decisions for me?
There is. There's 2 that are very important. One is for healthcare decision making. I kind of always put them in 2 pots for clients. And one is for healthcare decision making and one is for financial. So essentially anything you can do with your money, appointing someone who could do with that, money, assets, anything essentially of monetary value. And then healthcare decision making, what kind of treatment you're going to have, things like that, doctors, consent, those kind of things. And there are documents for the planning of incapacity. So I'm really glad that you use the car accident example because that can happen to anyone of any age, right?
Yeah.
Right. And so planning for that incapacity where you're not able to cognitively make those decisions for yourself, you've nominated someone else to do that for you. And that can happen, when you're elderly and you're starting onset of dementia, or if you're in a coma from a serious accident. They're both relevant and important in those circumstances.
So if I'm 20, we talked about I'm 20, I don't have a kid, I don't have any money, I don't need a will.
Sure.
But what if I'm 20 and I'm in a car accident?
Right.
I'm not a child anymore, according
Right.
to law, so my parents can't make the decisions. So what happens if, I'm 20, I'm never going to die, and then,
Right.
as we would always joke at work, you get hit by the beer truck.
Right.
Who's going to make all those decisions for me if I do not have this piece of paper?
Well, right. And so financially, the financial power of attorney is more important in that piece because even if someone maybe is next of kin to a hospital and able to kind of give decision-making powers in that right, financially they're not going to be able to access your bank accounts or write checks for you or pay your bills. So nominating that person through the financial power of attorney it would be really important so that person can take on that role. But as far as a healthcare power of attorney, that a lot of times it's in the discretion of the medical provider, and typically next of kin is either children or parents, depending on the age of the person. So whether or not you have a close relationship with that person, whether or not you trust that person is
That's
huge.
just it.
Right.
So you've used the word power of attorney. So for the money part of it,
Right.
I can have a document that says so and so, Jane Doe, whoever my best friend or my partner or whoever my child is, they can actually write checks on my behalf. They can pay bills on my behalf. Because what happens if I'm in that coma and then one day miraculously I come out of it? Do I really want to be dealing with 6 months of nobody's paid anything?
Right, exactly.
To me, that would be the hard thing. During my 6 months, hey, I'm happy, and then boom, 6 months later, all of a sudden my financial world is crumbled.
Right.
So can I go to an attorney and just say, hey, I want one of those documents where I can name my parent, my child, my spouse to be that?
You can, and there's different ways to structure it. So I'm thinking of the 21-year-old, for example. Maybe you don't want to give someone exclusive power of attorney because you expect to be well for a really long time. There is language that you can put in there to say upon my disability, or upon my incapacity. So if it's in a lot of circumstances we don't love to put that in there because it then requires a certification from a doctor. But if someone's uncomfortable with maybe giving that power without necessarily foreseeing incapacity in the near future, that can be done, or you can limit it. You can limit the powers. I mean, you do limited power of attorney for real estate closing. You can limit it to that transaction, or you can make it as expansive as the statute allows.
So if I'm 21, I can actually have a document, or 31 or 41, whatever, that says you can pay my bills for this kind of thing, but you don't have like free reign. Like, I'm not going to come home one day and find out, hey, you've sold my house and you've sold my car.
Right. You could limit it. I mean, that's maybe less frequent, but you can certainly limit it to certain transactions or things like that, whether it's like the sale of a certain asset or the managing of a certain account or something like that. Or, typically the standard power of attorney allows for broad powers for the planning of general incapacity for a long period of time.
Yeah, because nobody wants to, be hit by the beer truck when they're out.
Sure.
But then I get to the point where, okay, somebody's going to take care of the money, and then somebody needs to be making decisions. Because earlier you said, well, there's a doctor in the hospital. I've never met this doctor.
Right.
They've never met me. I'm just a person lying there. They have no clue what I want.
Exactly.
And that's what scares me the most, is that something's going to happen and nobody's going to have any idea of what my purse. But I'm not going to carry around this piece of paper in my purse all the time.
Right.
So how do they know? So I guess the first thing would be, I go to the attorney and they'll help me through this process. Right. And what are some questions I should think about for who gets to decide what's going to happen to me if I'm in the coma? Not the money part, but the health part.
Right, and I think that's exactly right. It's who you trust with that discretion, who maybe you've had the most candid conversations with all of that.
So now I have to talk about what's going to happen when but I don't want to.
Or there are, you can incorporate into those documents, what are your end of life wishes, whether you are, not opposed to pain medication, even if it hastens your death, is language that's been used, or organ donation or cremation. All of those things can be incorporated.
But wait, on my driver's license, it says I'm an organ donor.
Right.
So this is going beyond, I'm an organ donor. This is where you say, do I want to be medicated?
Right.
To take the pain away?
Right. Do I want artificial hydration or food?
So that means putting like the tubes down me.
Right. Yep.
And I don't know that anybody would say, oh yeah, that's, I'd love to just be lying there for months on end.
Right.
So I want to have that ability to make that choice.
Right.
But how do the doctors, let's say I'm in the car accident, again, I'm not going to be carrying this around, waving it around, oh, look at my medical thingy.
Yeah.
What do we call it? A medical
healthcare power of attorney.
Healthcare power of attorney. So look at my healthcare power of attorney.
Or advanced directive to the CNA, yes.
A lot of words. I call it what's the piece of paper that says how to do the medical stuff. So how do they know if I'm hit by the beer truck, I'm in the hospital, they don't find it in my purse, surprise, surprise, I'm not carrying it around. How do they know? How are they going to find somebody who says, oh yeah, I know where this is?
Well, I think that a lot of medical offices I've found have gone to electronic record keeping too. So you can scan, I've had clients scan and email it to their physician's office that has a global network of, but again, if you're across the country and no one who knows you, that's obviously less than helpful. But I encourage clients to keep electronic versions and making
But
sure
how are they even going to access that?
And that's a great question. That's I guess then that boils down to provide who having that conversation with those agents that you've appointed to have that power, right? But there's not some universal registry where these things are put and
that's
found.
What I'm wondering, because last
time
I had to have just a minor surgery, and it kind of freaked me out when they're going through, and they do the thing if you go in for surgery, what's your blood pressure, all that, and then they say, do you have what is it, medical power of attorney? Which I knew was, here's what's going to happen, and if I become unconscious or if I'm getting close to death, and it kind of freaked me out. Like, I'm in here for a minor surgery, and you're asking me if I have a piece of paper,
right?
And luckily I said yes, but you're right. I don't think my doctor has it. I think I need to get it to my doctor,
right?
Because at least they know who my doctor is,
Right, exactly. And I've had clients come actually from their doctor's office with blank advanced healthcare directives. And while some of them are they're structured a little differently than ones I've seen, they typically comply with the statute. And I think probably if you get one from your doctor's office and need to do that emergency, in an emergency or in a rush situation, that's probably fine. But I would typically have it reviewed by an attorney just to make sure it complies with the statute.
Yeah, because I honestly don't want to be doing this. Like, oh my gosh, I'm going in for surgery. Oh, sign something, because you know what? I might not be in the best frame of mind. And it really did kind of make me really uncomfortable because I
Right.
think I looked at the woman and said, I'm just here for minor surgery.
Yeah,
You
I'm
know,
not here to
this
make
is-
these
This is
decisions."
just going to take like
Right,
30 minutes.
right.
Why are you asking
Yeah,
me this?
Right, yep.
But I think they said, oh, we do have one. Well, you know what? Now's not the time I want to be thinking
I'm not
about
amending
it.
it, yeah.
So just to go over real fast, the will is going to say, here's who gets my kid, and here's who gets my money,
Yep,
and I get to choose that.
correct.
Now, what if later on, 5 years down the road, I change my mind? Can I change my mind? Can I go back and change my mind about who gets my kid and who gets my money?
They're always amend, and that was going to make that point too. You can always amend your will, provided that you have the capacity to understand what you're signing,
Okay.
and can demonstrate that to whomever is drafting and executing your will with you. As long as you have that capacity, you can amend your will through a codicil, which would be a minor change, or just shredding the old will and redoing it. The same with the powers of attorney. They can be amended or revoked at any time by either just tearing it up and giving notice to your agent saying I revoke my power of attorney, or creating a new one, which would therefore revoke anyone's previously.
Yeah, because what if I'm married? I'm doing the right thing. Power of attorney. That's the money stuff.
Right.
And then I get divorced and meet
Right.
my new spouse, and all of a sudden, oh my gosh, my old spouse, who maybe I'm not on the best terms with, maybe that's why we're ex-spouses,
Yes.
all of a sudden has the ability to do money things.
Right, right.
And my new spouse is sitting there saying, but.
Right.
But so the old one will still be valid if I don't change it?
Unless there's language in there to say that it's implicated by a divorce, I would certainly encourage anyone to
Oh,
assess.
so I can actually write that in saying, hey, if I get divorced,
Arguably, yeah. Arguably, it's revoked upon my divorce, right?
and I could do the same thing with it's the healthcare directive or the
Right,
medical power of
right.
attorney.
Yep.
Because if I'm lying there and my health is in crisis, I don't want my ex to be
Right,
making the
Right,
decision because they're an ex for an ex.
Yeah. Marriages and divorces are a great time to assess your planning documents.
True, that's true.
They really are.
Because I've heard of people where, they had one spouse, got divorced, got remarried, and they died, and the ex-spouse got everything.
Right. They're right.
Well, the new spouse isn't really that happy about it,
right.
but is there anything the new spouse can do?
Depending on the circumstances, there very well could be, depending on the circumstances. Some of the statutes, would maybe nullify portions of the divorce. Can, in some statutes, in some states, nullify certain provisions in a pre-existing will, depending on when it's executed and the circumstances there.
But if I want to save time and money and
Right.
I want to be nice to my spouse, my
Right.
current spouse, when I die. I don't want to put them in the position of
No,
having to go
that's
to
pretty
court.
much- yeah.
I don't want to put my child in the position of having to go to court and say, wait, here's who I want to live
Right.
with, and having
Right.
people fight over who they live with. That
Right.
is not what I want to do. Well, thank you so much for coming in. I know that nobody wants to talk about it.
Right. It's tough.
So here's everybody's goal this week. Start thinking about it, make an appointment, find somebody to go talk to, find an attorney, go see some friends or relatives, see who they would suggest, because it will save a whole lot of awfulness after you die or when you get sick. If these documents are there, because I want everybody to love you just as much and remember you fondly after you're gone and not be having to wade through all this paperwork. So there's my challenge for you, and thank you for watching, and have a great week. So,